Congress and the courts manipulated Indian law to promote westward expansion of the U.S. in the Northwest Ordinance of 1787. Most recently, Indian tribes have filed suit to force the federal government to account for billions of dollars it has collected over the years for leasing of Indian lands. So I wrote the Northwest Ordinance of 1787 was a good faith ordinance, and so relations were pretty good. Well, as good as they could be, I suppose, until the Dawes Act of 1887, and when they decided that assimilation, so adopting American culture, would be a better policy than separation for the Native Americans. One of the ways that they assimilated Native Americans was through boarding schools, including the one in Western New York.
That's a song that was counting dead Indians back on the trails when they would kill Indians.
See all these little kids in uniform, and we'd be wondering how come they're like that. We weren't dressed like that, but these little kids were.
I remember being younger, growing up on a reservation, and being told, don't trust white people, don't listen to them. Never told why.
The government schools are constantly being built and hospitals added. We bring them in, clean them up, and start them on their way to civilization.
I would ask social services and human services audience, how many people know about residential boarding schools? How many people here do? This never makes it into the history books. This is never talked about.
Why did those schools get started, and who started them, and what was the rationale behind it?
And the first general policy was the only good Indian was a dead Indian, that we needed to be killed, exterminated, eradicated. Once they realized that's a little bit more difficult to do, is to have mass genocide of a population, the policies changed from killing to killing the Indian and saving the man. There's a General Pratt who was well famous and documented for using those words to kill the Indian and save the man, and that we are subhuman, and that our ways are savage, and we need to be civilized. Well, the governments in Canada and the United States followed that policy up until the 1980s. In one form or another.
There is a boarding school far, far away where we get mush and milk 3 times a day. Oh, how the huskies run when they hear their dinner bell. Oh, how the huskies run 3 times a day. Like I say, I went to the mush hall when I was 4 years old. I was there for 9 years. And once in a while we'd come home on summertime, but not all the time. When the counselors came and told my dad that he couldn't raise us properly, we were at the mush hole 1 week and our heads were full of bugs.
Well, there was a lot of sad times, but I mean, like, I didn't get like angry and have any resentment until after I got out, because I didn't know, like, from 5.5 to 16, they just thought it was just like a normal upbringing, like to not have no parents and stuff like that. So that's And after I got out, and then they thought, well, this is the way they were supposed to be treating us. I think my mother couldn't take care of us because our father was into alcohol. Me and my sister, we started there in 1945. I was 5 years old at the time.
We had all our hair cut off. We were made baldies. We were really bald. And that wasn't a very good feeling to have. And they used to call us mushhole baldies. That's what the kids on the reserve used to call us.
So this goes on, and I encourage you to watch the rest of it. It looks like it is available on YouTube. It's called Unseen Tears, and it's a phenomenal movie or documentary. I would highly recommend you see that. But that gives you a little bit of a taste into the assimilation policies over separation of the American government. And I can tell you that was not, that was fairly racist. The Indians finally got the right to vote in 1924. You'll notice that's just after the women got the right to vote. And the Native American Rights Fund in 1970 is basically the NAACP of American Indians. In recent years, lands have been reclaimed by Native Americans through successful court cases, which have slowly and gradually increased political clout. Native Americans have made huge financial gains, and so they've been able to make huge contributions to political campaigns, thus gaining more political power and having more say in their government. You'll see as well, also at various points, the various groups have taken over federal landmarks and tried to reclaim lands. One major example of this would be in Alcatraz. And every year you'll see, the day before Thanksgiving, there's a group of people that go out and honor the Native American land that was taken. There was actually an occupation of the of Alcatraz by Native American Indians for several years throughout in our history. So I encourage you to look into that. These are a couple of photos from that time. Okay, moving on to Asian and Pacific Americans. In 1882, the Chinese Exclusion Act restricted Chinese immigration specifically to the United States. This was followed in 1886 by Yik Wo v. Hopkins, and this was a case about San Francisco dry cleaners. Many of the launderers in San Francisco worked out of buildings that were made of wood, and a law was passed, and specifically, I think over 70% of them were owned by Chinese Americans. And a law was passed saying that no laundry could be in operation that was in a building made of wood. However, this failed the rational basis test, and winning Yik Wo rights to continue using his laundry as a business. In 1922, Asian and Pacific Americans were also deemed not white in a landmark court case, and therefore, as non-white Americans, they were not entitled to full citizenship rights. And that's important because that leads up to 1941 with the Japanese internment. Here in the Bay Area in San Francisco, we have several places that were actually used as Japanese internment camps. One is Angel Island, which some of you may have been to in the San Francisco Bay over in Marin by Tiburon and Sausalito. And also the San Francisco Presidio was a former military barracks and an area where many Japanese were interned. Korematsu v. United States was a court case in which Korematsu refused to go to an internment camp, and so he brought a court case. And he said that basically he was being discriminated against and he wasn't being allowed equal protection. What's interesting is this is a step back for Asian American rights. Japanese internment camps were deemed constitutional during World War II because this is the first time that the court had applied the strict scrutiny to racial discrimination cases. So they said that the Japanese internment camps were constitutional because they were necessary. The rights of the government superseded those of the individual in this case. In the 1970s and 1980s, I also wanted to bring up the idea that Filipino farm workers joined in the United Farm Workers movement with Cesar Chavez. And in California specifically, Asian and Pacific Americans have gained political power by getting more men and women elected to government and at the state and local level today. That's in more recent times. You won't see that everywhere in the country. California is one of the states with the largest Asian population, but it's a group of the population that's making significant gains in politics. You also should know about the American with Disabilities Act. The ADA, or the American with Disabilities Act, is the reason why so many public facilities are required to be wheelchair accessible, or the same reason you'll go to the bank to an ATM and you'll feel Braille on many of the keys. So the ADA, American with Disabilities Act, is the first act that defines disabled as someone with a physical or mental impairment that limits one or more life activities. And most importantly, it extends the protections of the Civil Rights Act of 1964 to all those with physical or mental disabilities. So that's pretty significant. It also requires buildings to be accessible to people in wheelchairs, etc. Okay, moving on to another discriminated against group, gays and lesbians. Gays and lesbians have been subject to extreme discrimination. Overall, they tend to have higher incomes and higher education levels than other minority groups. A key piece of legislation that you should know about is Don't Ask, Don't Tell. Gays wouldn't be asked about their sexual orientation, but they were barred from revealing their sexual orientation. And this was under Bill Clinton. Bill Clinton has some things to say about this.
Do you ever regret it as a policy?
Oh, yeah, but keep in mind, I didn't choose this policy. Don't Ask, Don't Tell was only adopted when both houses of Congress had voted by a huge veto-proof margin to legislate the absolute ban on gays in the military if I didn't do something else. That is, they'd made it clear, both houses in their votes by veto-proof margins, they would never let me order, by executive order, gays to serve in the military. So it's some big myth that somehow it rolled for the military. The Congress voted, and I got beat. And so did the gay rights people got beat. So there's been a lot of rewriting history saying, oh, Bill Clinton just gave in to that. That's just factually false. I didn't do anything until the votes were counted. Now, when Colin Powell sold me on Don't Pass, Don't Tell, here is what he said it would be. Gay service members would never get in trouble for going to gay bars, marching in gay rights parades as long as they weren't in uniform, getting gay materials for any of the places they went or any of the things they did, as long as they didn't talk about it. That was what they were promised. That's a very different Don't Ask, Don't Tell than we got. What we got as soon as General Powell retired was this vicious mid and low-level officer feedback where they, for a year or so, made it worse than it had been before. Then they sort of settled down. But the reason I accepted it was because I thought it was better than an absolute ban, and because I was promised it would be better than it was. But the world has changed now. There's a huge shift in opinion, and I think we're going to prevail in this. I think that, the Republicans are making a big issue against gays serving in the military in the election, but unless they can somehow stir it up again, I think that our military commanders will implement it.
Okay, so that was back in 2010, and I just thought you might want to see his perspective on it. There have been several other court cases as well since then. Romer v. Evans, 1996, was a Colorado law that denied homosexuals the right to seek protection from discrimination, and it was seen as unconstitutional under the Equal Protection Clause of the 14th Amendment. Lawrence v. Texas is another court case in which the court reversed the decision that banned sodomy as unconstitutional. In 2003, Massachusetts Supreme Court ruled that denying homosexuals the right to civil marriage to be unconstitutional and under the state's constitution. The Supreme Court refused to hear an appeal. Sometimes it's what the Supreme Court doesn't do, right? The Supreme Court refused to hear an appeal, thereby saying that their decision stands. In California, you may have heard of DOMA, the Defense of Marriage Act, and Prop 8, and it's important for you to know about it. Sorry for the ad, guys. That was not intentional. Sorry for the ad.
In a landmark move for gay rights, the Supreme Court has struck down the Federal Defense of Marriage Act in a 5-4 decision, but avoided a ruling on gay marriage. It ruled the 1996 law, which denies more than 1,000 federal benefits to gay and lesbian couples, is unconstitutional. A major victory for gay rights activists who've been waiting for the court's possibly life-changing ruling. Justice Anthony Kennedy, joined by the court's 4 liberal-leaning justices, issued the majority opinion writing, "The Defense of Marriage Act violates basic due process applicable to the federal government." Kennedy did make clear the ruling applied to couples in states whose marriages were lawful, meaning it won't apply to those living in the 38 states that still ban same-sex marriage. Those couples can now receive tax-free benefits from their employers, survivor benefits, and the ability to file joint tax returns. And on Proposition 8, the California law that bans same-sex marriage in the state, the High Court said it had no standing, meaning the lower court opinion will stand and gay marriage in California is again legal. 12 states and the District of Columbia have adopted same-sex marriage. For Newsy, I'm Megan Murphy. Multiple sources, a broader view.
Okay, so hopefully that helps to clarify a little bit about what Prop 8 was and the history of DOMA. Moving on to affirmative action. Affirmative action is the idea that there are policies designed to give special attention or compensatory treatment to members of a previously disadvantaged group, for example, racial, ethnic, or gendered minorities. These debates were particularly heated under Reagan, but the Supreme Court actually ruled to protect minority groups. One of the major court cases here is Regents of the University of California v. Bakke in 1978, which outlawed quotas but upheld affirmative action. Another one you've heard about is the Michigan Law School court case. We've discussed that in class. Okay, quotas are specific numerical goals for admissions or employment. And here are a couple of other, here's the Grutter v. Bollinger. So Grutter v. Bollinger of 2003 upheld University of Michigan Law School's admissions policy, which gave preference to minority applicants. So it allowed schools to use race as a factor, which was affirmative action, but not quotas. The Supreme Court basically has ruled on affirmative action that strict quotas are not constitutional, but there's a place for some preferential treatment until greater racial and ethnic parity is achieved while examining each applicant, quote, as an individual and not in a way that makes an applicant's race or ethnicity the defining feature of his or her application. That was Sandra Day O'Connor. Okay, so your turn. What is the difference between affirmative action and quotas? Number 2, name one court case to do with affirmative action. What was the decision? And question 3, where does the Supreme Court currently stand? So take a moment, answer those questions for yourself in your head or on a piece of paper. And we're going to move on. Pay equity and workplace discrimination. You can always go back and check your answers. Okay, so Lilly Ledbetter Fair Pay Act of 2009, I discussed that briefly earlier, and the act amended the Civil Rights Act of 1964 to state that the 180-day statute of limitations for filing an equal pay lawsuit regarding pay discrimination resets with each paycheck affected by that discriminatory action. The law directly addressed Ledbetter v. Goodyear Tire, a U.S. Supreme Court decision that the statute of limitations for presenting equal pay lawsuit begins on the date that the employer makes the initial discriminatory wage decision, not at the date of the most recent paycheck. So basically it was arguing that So, for example, if she had been working for them for 10 years and the statute of limitation was 9 years, that the statute of limitations resets every time she gets paid, as opposed to just that very first time that she got paid and the very first time that they decided to pay her less than a man of equal abilities. Here I have another great link. This is a brief documentary about Lilly Ledbetter, who she was and what she did. It's 23 minutes long. I highly encourage you to watch this on your own. It should enhance your understanding of Ledbetter and Goodyear Tire. And as young women, I really hope that you're interested in learning about this fantastic woman who went to court so that you can get paid the same as your male counterparts. Okay, lastly, the 26th Amendment is one that you need to know. Section 1, the right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the U.S. or by any state on account of age, and Congress shall have the power to enforce this article by appropriate legislation. So basically, the 26th Amendment means that you can vote this year or next year. Okay, here I have a couple of practice questions for you guys that I would highly recommend that you take some time to answer. There's practice question, multiple choice here, another multiple choice question here, and a practice short response for you to tackle. I would highly recommend you do all of these in preparation for the exam on Wednesday. Let me know if you have any questions, and good luck.